Welcome to this presentation on neuroforensics, where we unpack how brain activity is being proposed as evidence in criminal investigations. Over the next slides, we'll explore the scientific limits, legal challenges, and ethical stakes of using neuroimaging in court, and outline cautious pathways for responsible application rather than sensational claims of mind reading. In many cases, intent, deception, memory, or trauma leave behavioral proof inconclusive, and courts feel pressure to admit neural data as a last resort. This slide highlights how that pressure raises the stakes for accuracy and reliability, because admitting weak or misunderstood neuroevidence can distort justice rather than clarify it, creating broad implications for the legal system. fMRI faces three big reliability problems. The scanner measures blood, oxygen changes, not direct neural firing. Statistical maps rely on group averages that obscure individual differences, and scans taken long after an event struggle to reflect the mental state at the time of the crime. Taken together, these gaps make translating fMRI patterns into courtroom facts highly uncertain. EEG offers millisecond-level temporal precision, which can capture rapid neural responses, but it suffers from spatial blur that limits precise localization. Event-related potential paradigms have been explored for lie detection and memory assessment, yet they remain vulnerable to countermeasures, motion artifacts, and interpretive challenges that create significant admissibility hurdles in court. Moving from lab tasks to real-world intent requires an epistemic leap that is rarely justified. Controlled experiments use simplified stimuli and idealized conditions, often lack baseline scans for comparison, and ignore environmental confounds like stress or substances. Crucially, legal constructs such as intent and responsibility lack straightforward neural proxies, so direct translation to legal proof stays speculative and context-dependent. Courts act as gatekeepers under standards like Frye or Daubert, demanding scientific validity, peer review, known error rates, and general acceptance. Case law has already been skeptical, excluding many neuroimaging techniques in forensic contexts, and flashy brain images alone do not pass reliability tests. The message is clear. Visual appeal cannot substitute for rigorous scientific substantiation. Brain scans have a seductive visual power that can overwhelm juries and tempt overinterpretation, a tendency called neuroessentialism. That risk factors into legal balancing tests like Rule 403, which weigh probative value against unfair prejudice. In many cases, the potential to mislead or confuse jurors outweighs the modest probative benefit neuroimages currently offer, supporting exclusion in sensitive contexts. Neuroforensics also raises ethical and constitutional questions. Could brain-derived data be treated as testimonial and implicate the Fifth Amendment? Or does it threaten cognitive liberty and mental privacy? Any use of neural data should require clear, informed consent, protection against coercive collection, and careful safeguards to prevent unwarranted surveillance or intrusive mind-reading technologies. To reduce harm and improve reliability, this slide proposes safeguards, like validated task protocols, impartial expert testimony with conflict disclosures, mandatory disclosure of alternative interpretations and countertests, and judicial checklists to guide admissibility. The conclusion emphasizes neuroevidence as modest, corroborative material rather than standalone proof, only acceptable when integrated with traditional evidence. The bottom line verdict is that current neurotechniques are insufficiently accurate to definitively decode criminal intent or link brain patterns to specific acts. Strategically, neuroevidence should be used to supplement and corroborate behavioral proof witnesses, forensics, context, until robust causal links and reliability metrics are established that justify broader forensic reliance. Judges should demand replication studies, require baseline comparisons to determine whether an individual's pattern is truly anomalous, and insist on quantified error rates for techniques presented in court. They should also consider less prejudicial alternatives before admitting neuroevidence, translating scientific limitations into practical courtroom rules that protect fairness while allowing careful, tested uses. Building a reliable seat for neuroforensics in the courtroom will take large, diverse, forensic datasets, ecologically valid tasks that mirror real-world scenarios, standardize analytic pipelines to reduce subjectivity, and sustained interdisciplinary collaboration between scientists, ethicists, and legal experts. With those investments, neuroevidence might become defensible and admissible as a corroborative tool rather than a dramatic standalone claim.